Well, good evening, everyone. Good evening. I want to thank you all for coming out tonight. This is an important night. And first, before I talk about why we're here, let me say thank you to our outstanding City Council member, Darden Rice, for your leadership on this issue, to my good friend, our County Commissioner, Ken Welch, for your leadership from the county level on this issue, and to Eve Epstein on our staff for all of your hard work. Tonight, we're here to talk about wage theft. And you know, we've done a lot in St. Petersburg to protect workers, to make the lives better for our workers. And a wage theft ordinance, and the city's wage theft ordinance, is really a critical part in protecting the workers in the city of St. Petersburg, to protect those who suffer the effects of unfair business and labor practices. Without our wage theft ordinance, workers have been treated unfairly by their employers, and they have few options to pursue when they are being treated unfairly. To us, this is a really critical piece for us to reach our vision as a city of truly being a city of opportunity, where the sun shines on all who live, work, and play. It's pretty hard to have the sun shining on you when you're working hard and you're not being paid for the work that you are doing. It's really about trying to level the playing field for those ethical businesses who are out there trying to do it the right way and do it the way they're supposed to, and competing against those who aren't doing it the way you're supposed to, and who aren't following the law and paying what they're supposed to be paying. And so again, I want to thank you all, thank the panel for your participation tonight, and with that, I'm going to turn it over to Darden Rice.
Thank you, Mayor Kreisman, and thank you for your leadership and vision with the City of Opportunity Initiative. And our wage theft ordinance is one more way that the city is moving the equity agenda forward. I would like to introduce our fantastic panel of speakers and tell you a little bit about what we're doing here today. But first, let me introduce Pinellas County Commissioner Ken Welch. Hello, Ken, who's been a great leader for wage theft prevention on the county level. We also have Eve Epstein, our wage and hour compliance coordinator. We also have with us Chris Schulman, you have a long title, Chris, but it's the City of St. Pete Wage Theft Prevention Program Hearing Examiner and Pinellas County Special Magistrate for wage theft hearings. Great to have you here. And of course, we have Paul Valenti, who's the Director of Pinellas County Office of Human Rights. So, and welcome everyone here in the audience. Just a quick reminder, we are taping this panel discussion so that we're able to share this information both on the city and county channels. And we can make the copy of the PowerPoint presentations that you'll see, we can make that available to you. Thanks for signing in. So today, we are here for this panel to discuss wage theft prevention. Commissioner Welch and I will start things off by explaining how we got started working on this issue and why. And we'll hear a specific example of wage theft from one of our citizens who's here today, Scott Snurpus. And Eve Epstein and Paul Valenti will walk us through the details, the qualifications, and the process of contacting your wage theft prevention office. And lastly, we'll hear from Chris Schulman on the hearing process. And we're glad to take questions from the audience at the end. So first, what is wage theft? Not too long after I was elected, a constituent asked me, what are you doing about wage theft? And my first reaction was, I wasn't sure exactly what he was talking about. And I said, surely we already have laws for wage theft. It turns out, not very adequate ones. And I wasn't sure how much this was, how prevalent this was happening in our region. And it turns out wage theft is happening a lot, especially here in Tampa Bay. So that person's single question led me down a path of research and even attending a conference in Minneapolis where I learned a lot more about the wage theft epidemic. And even better, I had the opportunity to study model local legislation to adopt here in St. Pete and Pinellas. And as I learned more about it, I started hearing more stories from victims of wage theft, And I knew that a local ordinance was the right thing for St. Pete to do, especially given the bigger picture about low wages in the Tampa Bay metro. Tampa Bay has the lowest per capita income of any major urban area, and we know that income inequality is what has hampered our recovery from the recession. So people simply just can't afford to have part of their paychecks go missing, and why should they anyway? That's money that they earned rightfully in the first place. It belongs in their pockets. So the basics. Wage theft is non-payment for work owed. It could be misclassification of independent contractor status. It could be a bounced check. It could be loss of overtime. It could be not getting paid the minimum wage, and sometimes getting paid very late, or in some cases not even getting paid at all. We do have some federal data that is very telling, and one of the reasons it moved us to act so quickly on this. In Pinellas County, we know that from 2012 to 2014, in 2 years, we recovered $7.5 million, and that was nearly 15,000 Pinellas County citizens who were affected, and the average case that impacted them was approximately $500. And that was just the tip of the iceberg. The state has very little protections, and the federal level is understaffed. So currently, Florida has no state equivalent to the Department of Labor to investigate wage and hour complaints, and doesn't have the staff to investigate its minimum wage law. As of June 2014, the Florida Attorney General had not brought forward one single action to enforce the state's Minimum Wage Act that was enacted in 2004. So on the federal level, the Department of Labor simply does not have the resources to pursue the volume of wage theft complaints. And although the Department of Labor can investigate discrepancies in the federal minimum wage, they do not have the ability, like we do at the local level, to investigate promised versus minimum wage complaints. And we're going to get into that in a few minutes in our presentation. But we do know the city can't tackle this on our own. Even though St. Pete was the first city in the state of Florida to enact a wage theft ordinance, we opened our doors August 31st, 2015. We know that this approach really only works best for all of our citizens with a larger, more coordinated approach. And that is why I am so thankful for the leadership of Commissioner Ken Welch, who has taken this issue to a larger level. And with that, I'd like to introduce our Commissioner, Ken Welch, to talk about what we're doing at the county level.
Thank you, Darden. Good evening, everyone. It's really an honor to be here. And, you know, when you think about issues required to move our community forward, there are some that, you know, sit below the radar until someone or a group of folks elevate that issue and make it a focus. And truly, wage theft is one of those issues. Being a member of the Florida Association of Counties and working with colleagues from around the state, including Broward and Miami-Dade, you know, I'd heard about wage theft as an issue that they were addressing, but until Councilmember Rice brought that to the focus of Tampa Bay, we really hadn't addressed it in the Tampa Bay area. And so I just want to thank, I'm going to call you Commissioner Rice, and I knew I was going to do that. We serve on PSTA together, and we're all commissioners there. But Councilmember Rice, thank you for bringing this forward as an issue and really being the first in the Tampa Bay area to do that. So our goal, and I also want to say that the county and the city have the best working relationship that I've seen since I've been a county commissioner. So it's really a focus on what's best for the entire community. So after I read that Florida International University report that showed Pinellas County as 3rd or 4th, depending on which time period you looked at, 3rd or 4th in the state in wage theft, I approached Darden and we talked about it, and it was a collaborative process. He invited me to several workshops, and our goal was to, as St. Pete moved forward with their process, look at how we could take this county-wide, as Darden said. And so we did move forward. The County Commission unanimously adopted a wage theft ordinance in November of 2015. That became effective January 1, 2016. I do want to recognize Paul Valente, our Director of the Office of Human Rights, for all of his work. And there was broad consensus on this. We had support from the Council of Mayors, who supported this unanimously. I don't think we had any opposition from any business group, because this really helps those businesses who are working by the rules and really targets those businesses who are undercutting and not playing fair. The goals also aligned with one of the county's focus areas in terms of poverty reduction. And in terms of hitting that low-hanging fruit, folks who already have a job, already are working, if you just make sure they're paid what they're owed, that's a great way to make sure that folks can work their way out of poverty. Also supports our minimum wage laws, and it was written very similar to the Miami-Dade ordinance in that the target here is really to encourage mediation, and the majority of the cases are solved or resolved at that mediation or conciliation step, and that's what we hope to see here as well. And so I'm just excited about where we are. We've implemented, so now that everyone in the county has a person to go to, and I'm looking at you, Counselor, Magistrate, if they have a problem. And we didn't have that in Pinellas County before. And I think the plan going forward is we'll monitor the county's ordinance and the city's ordinance. It's really, to anyone that needs help, it is really the same ordinance countywide. So they have that protection, and moving forward, we'll make adjustments as necessary. And the county's included $50,000 in our budget, this year's budget, to help support this effort. And if we need more for next year, Paul, you have to raise a flag and let us know. But we want to fund this because we believe truly this is the right thing to do to move our county and city forward. So I just want to thank you for your leadership and looking forward to the rest of the county.
You're welcome.
All right, thank you.
Thank you very much. So now we would like to have someone from our community come up. This is Scott Snurpus, who, and Scott, come on up and stand at the podium. And I want to thank you for sharing your personal story, not a pleasant one, but I think the personal stories are so compelling to help people understand the impact and the prevalence of wage theft in our area. So go ahead, thank you.
Hi, my name's Scott Snurpus, and I was a victim of wage theft. I was working through a temp service out at the St. Petersburg Veterans Hospital, and the contractor I was working for wasn't paying me the Davis-Bacon wages that are due on any type of a federal job. So this was a little over a year ago before we had passed the wage theft ordinance here in the city of St. Petersburg. So I really didn't have anywhere to turn to. I was talking to a few friends of mine, and they knew somebody at the federal level for the Department of Labor, and we handled it at that level. But it took a lot of time. I think it was over 6 months or a year before I actually saw anything happen. And I'm just glad that we have something that, somewhere where we can go at the local level. But wage theft takes many forms. I mean, most recently, general contractor we were working for ordered one of our contractors to dock all of our pay 30 minutes because we had left work 1 minute early. So, I mean, wage theft can be pretty much anything. That's all.
Okay.
Thanks.
Okay, thank you, Scott. Thank you for sharing your story, Scott. And thank you. I know it's hard because there's dignity in work, and it doesn't feel good. It's insulting when you're not paid what you're owed. And I think your story speaks to a couple of things. That although typically when we talk about wage theft prevention, we're talking about low wage work, it really actually happens everywhere. And this speaks to the need of us stepping up our wage theft policy on a regional level as well, because especially in an area like construction, these are regional jobs, so this is bigger than St. Pete, bigger than Pinellas County. So thank you for sharing the story. And we're going to move on to Eve Epstein, who is our wage and hour compliance coordinator with the City of St. Pete. And Eve is going to walk us through the steps of what does it mean if you think you're a victim, and how do you go through the steps of filing a complaint.
Thank you. So the first thing I'd like to address are 4 common questions I get when people contact our office. The first is just generally, how do you qualify for the program? So the first qualification is that you're an employee, not an independent contractor. The work then, to qualify for the St. Petersburg program, has to have been performed within the city limits. For the Pinellas program, it can be anywhere in Pinellas County. Both ordinances have the same wage amount, so it needs to be at least $60, and that's the claim that you file is for at least $60. In terms of the filing, St. Petersburg, when we had the ordinance go into effect, it went back in time to 12 months. So from this date on, it's as long as you file within 12 months of the wage theft occurrence, you qualify for the program. For Pinellas County, their ordinance went into effect on January 1st of this year. So for those claims, it needs to be January 1 on. But otherwise, they operate the same. There are two other issues that could come up, but don't necessarily come up at the beginning of a case. If an employer files for bankruptcy, or if there ends up being a lawsuit involving the same claim, then we would lose jurisdiction over the case. But we really try to get people to focus on those first 4 questions. Now, my role as a wage and hour compliance coordinator isn't to make a judgment call as to whether someone is really owed that $60 or someone really is an employee versus an independent contractor. If you believe that you're an employee, if you believe that you're owed at least $60 and file with supporting documentation, I move the case forward. I will contact the employer, there's a mediation process, and then it will go to a hearing. So we'll discuss all those steps after that. But certainly my role is just to check those boxes, make sure you meet the minimum qualifications. Now the next issue that was brought up is the Department of Labor. We get a lot of referrals from the Department of Labor, and the big difference between what the Department of Labor can do and what our office can do has to do with the wage rate. So as Vice Chair Rice brought up, there's the difference between a promised wage and the minimum wage. Well, the Department of Labor, the Federal Department of Labor, can only enforce the federal minimum wage, which many of you probably know is 80 cents per hour less than the Florida minimum wage. And for tipped employees, it's actually more stark. It's around 2-something for tipped employees on the federal level. It's around 503 for Florida for tipped employees. So it's a very significant difference. But what's even more important about the ordinance is that it's your promised wage rate. So if you're promised $15 an hour, we enforce that. If you're promised commissions, vacation time, any sort of benefits, we enforce that. That is all part of your wage theft claim. That's money that you earned, that was your agreement with your employer, and we can proceed with that. So we actually offer a greater benefit when it comes down to wages that you were promised and what you can recover. Now, the third question I often get is about the supporting documentation. And what we really want to emphasize is this is not a process that requires an attorney, and it also isn't a process that requires you to have a lot of documentation. We understand that people may have informal relationships with an employer. So you're not required to show us an employment contract. Many people do not have employment contracts, that's understood. So when people ask me what sort of things might be helpful, I try to get them to think about how do you prove how much you were supposed to earn and how many hours you worked. So W-2s are helpful, pay stubs are helpful, but I also encourage people, if they have email conversations with their employer that says how much they were owed, there's a text conversation, print it out, attach it. My job is just to make sure that you are having a valid claim, at least that you're alleging that you were owed that much. I'm not making a judgment call at this point, and I can help you through a mediation, and we can have a conversation about what might be more helpful if it does go forward to a hearing with both parties in the room. Now, the fourth thing is if you look up at that PowerPoint, you're probably thinking to yourself, I know when I'm owed $60 or more. I know if I worked in St. Pete. I know if I worked in Pinellas. You might not know if you're an independent contractor. A lot of people don't know that. A lot of employers might not know that. And so there are 3 ways I try to address it. Number 1, someone usually says, what is an independent contractor? An independent contractor is someone who's self-employed. That means that you don't only not qualify for the wage theft program, you're not entitled to minimum wage, you're not entitled to overtime, you're not entitled to an employer contribution to Social Security, unemployment insurance. You're not an employee, you work for yourself. So that's a huge difference for people. So if you're in a situation where you think you were misclassified, you want to start thinking larger about whether you're an employee or not. So then they wonder, well, how do I know if I was classified or not? It's April, it's tax season. You might have noticed if you ever filled out a W-9. A W-9 form is commonly what's used for freelancers and independent contractors. Just because you filled out a W-9 does not mean you're an independent contractor. It means your employer thinks you're an independent contractor. So what I tell people is just because you look at those requirements and you filled out a W-9, don't think you don't qualify for the program. What's really going to come down to is being able to prove that you're an employee versus an independent contractor, which then gets into the muddy definition thing. So both ordinances apply the Internal Revenue Service's 20-factor test, and I promise you I am not going to go over 20 factors.
How about 19?
18 and a half factors. But no, there are three big umbrellas. And this is information that should be readily available for everyone. What I really like people to do is not only should they not disqualify themselves from filing a claim, but think about throughout the process of the mediation, if this does go to a hearing, how do I explain to a hearing officer I was really an employee? So the first question, it's a big umbrella, so just think about it as three umbrellas. The first one is behavioral control. So with behavioral control, you want to think about, where did I perform the work? Was I required to come to a company's business, or was it something I could do at home? Could I hire my own staff, or was I told who I need to work with? Could I decide on what projects I was going to work on? Was I working on a specific project, or was I being told what to do? The less control you have over your work, the more likely you are an employee. The next question is financial control. So think about it as profit or loss. If you come to a company and you assume a risk of loss, or you have a chance for making a profit, because you're investing in the equipment, you're investing in expenses, you're more likely an independent contractor. If, however, you come to a company and it's your company that's going to be making a profit off of your work, and you're not assuming any risk, then that company has financial control, they're treating you as an employee. And the third broad category is the relationship of the parties. Now I said you don't need to have an employment contract. It's great if you have a job description. That's very helpful to a hearing officer to figure out how much control there was in the place, what the relationship between the parties. But the number one factor here is how key your activity was for the business. So is this something central to the business? And a good example is a call center. If your job is to work the phones for a company, you're advertising for that company, you're making a profit for your company, you're an employee. You might be told you're an independent contractor because you're a telephone operator, but you're almost surely an employee. So what I encourage people to do is, if they look through these factors and they think, I might be able to tell someone I was actually an employee, I was misclassified, file a complaint. If you lost wages and you think you're an employee, there's no risk here, because you're going to go through the process. I'm going to offer you a mediation. We can see if we can facilitate a settlement. And if not, you already know what the factors are. You already know what you have to prove. And if you think you're at a point where you can tell a hearing officer, I'm owed this money, I'm actually an employee, go for it. So the next issue, we will actually now get to the nitty-gritty, as if that wasn't technical enough. So we'll go through the steps. So Mr. Valenti is going to go over how we get the process started, and I'm chime in a little about the mediation part.
Sure, thank you. And I guess before I start, my name is Paul Valenti. I'm the Human Rights Director for Pinellas County, and to underscore a point that Commissioner Welchin made earlier, he of course has the bird's eye view of between the relations of the county and the city. But at the level of, on this subject matter of wage theft, I can't compliment enough staff, and that staff being, of course, Ms. Epstein with the city of St. Petersburg and help. She's provided our office and referrals for complaints that were not jurisdictional because they weren't within the borders of the boundaries of St. Petersburg, but were within Pinellas County. So I think that's a testament to the working relationship that the commissioner, to which the commissioner referred. You know, the process is designed not to be difficult, right? A person who believes they've been subjected to wage theft simply contacts our office if it was outside of St. Petersburg but within Pinellas County. And in addition to the explanation that Ms. Epstein made, we also cover employers, even if the work was outside of Pinellas County, but it's for the benefit of a business with, or an employer within Pinellas County. I believe our ordinance to have coverage of that as well. And they simply contact our offices. We'll send them a complaint intake form, which essentially they would fill out and complete, return to us, so that we could assess the very checklist to which Ms. Epstein referred earlier. Are you making a claim for more than $60? Has it been within the last year? Are you claiming to have been an employee? If those check marks are, you know, we can check those boxes, we'll take that complaint and we'll serve it on the employer or alleged putative employer. And we'll give them a copy of the complaint so they know what's being alleged, and give them 21 days to provide a response. When we receive that response, we then try, as Commissioner Welch referred earlier, to really encourage a resolution through mediation. And that's when we hit the hoped for mediation stage that I'll kick back to Ms. Epstein on how that looks like and the benefits of that. But that gets us to the stage where you've got now a perfected complaint, you've got notice to the employer, and now we're going to hope to resolve it through mediation before we start, well, before we have to face Attorney Schulman.
So one reminder I make to a lot of people about the benefits of mediation. It's not only a free voluntary service that the city and county are providing, but it avoids the consequences of having to go to a hearing. If you lose at the hearing, you're going to owe 3 times the amount of the wage theft if it's proven, possible attorney's fees, and the employer, and costs to the city. So high consequences for the employer there, trying to get them into the room. So mediation, if anyone has read through the ordinance, they might notice that there's a word conciliation instead of mediation. The process we're really trying to encourage is much more mediation. I don't guide the process. I'm a facilitator. I get the parties into the room, I have them talk about the case, and I see if there's room for settlement there. And what's good about that is it's much more creative. It allows them to figure out maybe a payment plan that they could do, or making sure that it's paid in cash at a certain time. There might be considerations about a reference letter. It gives the parties an opportunity to come up with a settlement that otherwise they're not going to get if they're forced to go to a hearing. Is there anything else?
Well, and yeah, you know, I was remiss in mentioning, I think Ms. Epstein was a little generous in her earlier explanation of independent contractor, and that employers often might not know if an employee is an IC or not, but erroneously mischaracterize them as such. But I think, well, certainly I suspect that there are some employers who do that intentionally to evade their very obligations under ordinances like this and other legal obligations. So I guess I take a more jaundiced view on some of, at least, the activity going on.
And so I've been called on to sort of explain a bit about what that process entails. As the hearing examiner or special magistrate, I have what's called a quasi-judicial, I'm a quasi-judicial hearing officer, which has a specific meaning in Florida law. Essentially comes down to, as the word suggests, I'm kind of like a judge, right? I am the person who's going to make a decision in this particular case, but I'm not a full-blown judge. I am, however, impartial. I'm there to hear what the two sides have to say, and then in my role as fact finder, I determine what happened. Okay? Were you an employee? You know, did you work certain numbers of hours? Were you paid at the rate that both sides agreed you would be paid? I'm also the decision maker. So I'm the one who's going to decide whether, among other things, you were an independent contractor or an employee, whether the ordinance, whether it's the St. Pete or the Pinellas County ordinance, has been violated by virtue of the wage theft, and therefore what remedy would be imposed. My principal role when I'm there at the hearing is to run the hearing, okay? So I'm the person who's going to, we'll go over the process momentarily, but I'm the person who's going to go ahead and I'm going to decide what information that the two sides are presenting to me should properly be considered. While it is a hearing where I'm going to take evidence, it's not a full-blown trial. So the formal rules of evidence do not specifically apply, but a lot of the principles behind those policies do apply. So I'm going to be looking as a hearing officer, and we'll talk a bit more about this momentarily, whether the information that's being presented to me is reliable, okay, is it credible, meaning it's believable, and is it relevant to the issues that I'm there to decide. If your boss was a mean, nasty person, and that was an important feature of your life while you were working there, that's important but not relevant to the issue of whether your wages were stolen. Because my sole jurisdiction, if you will, one thing that I'm looking at is whether or not the wage theft ordinance has been violated. What I'm going to do is move on to the process, the hearing itself, okay? And there's a couple of sort of discrete stages as we go through. I'll convene the hearing, I'll go ahead and, which just means I'll start. I'll say, I'll welcome everyone there, I'll introduce myself, I'll say the date, time, and location where we are conducting the hearing. I'll ask the people who are present to identify themselves, at least those who are involved in the complaint itself. I'll also typically make a brief opening statement about the process, what it is the parties can expect from me and the process while we're there that day. I'll then invite each side to make opening statements. Now, neither side's required to, but they're allowed to. And an opening statement is really sort of a preview of what you think the evidence that's about to be submitted to me is going to show, and ultimately why it is that you think that I should rule in your favor. Neither side is required to do that. Parties often will do so. We then get into the actual meat of the hearing, which is where I will take the evidence from the parties. Recognizing that not every person who's there is going to be represented by either an attorney or someone else who's experienced in these sort of things. As the hearing examiner or the special magistrate, I will sometimes ask some questions to prompt folks so that I'm able to make sure that the record is adequate for me to make a decision. But ultimately, the burden is on the claimant and the respondent to put on the evidence that they think I need to consider. And when I say put on the evidence, what I really mean is make a statement under oath, okay? Testify. And so what will happen is, if, for example, you're bringing a claim, you'll go ahead, you'll be placed under oath by the court reporter, and then you'll go ahead and tell me the facts that you think I need to know in order to understand the merits of your claim. Okay? Where you worked, was it within the city of St. Petersburg or within Pinellas County, it's a county proceeding, what your agreed wage rate was, what hours you worked that you were not paid for, those sorts of things, okay? When you're done with your individual piece of testimony, the other side has the right to do what's called cross-examination, which, you know, I'm sure a lot of us have watched various TV dramas, the court proceedings, the Law and Order, and all that other stuff. And, okay, it's not nearly so intimidating as any of that. Really, the cross-examination, the purpose there is to allow the other side to ask questions about what has just been testified to make sure that I understand both sides of that person's testimony. Each side has presented their information to me. I then go ahead, I'll typically take a recess, which isn't as nearly as much fun as recess used to be. And I'll go ahead and I'll do some thinking about what I've heard, the evidence that's been presented to me, and then I'll make my decision about whether or not the ordinance has been violated. If so, I will go ahead and issue a written award, which I will read into the record, indicating how much money the employer has to pay and to whom. And the ordinance provides me as the hearing officer, the hearing examiner, or special magistrate with no discretion. What do I mean by that? If I find that a certain amount of money was stolen by the employer, I am required to award 3 times that amount to the employee. Okay? There isn't discretion of, well, it was an honest mistake, so I'll just make it 1.5 times or 2. No. It's either a wage theft or there isn't. And if there is a wage theft, treble damages. Okay? There are other costs that are associated with the process as well. And our program managers tell me what the amounts are related to that. Those costs typically are the program costs. My last topic is how do you folks might want to get ready for the hearing? And frankly, it's going to be sort of a summary of a lot of the things we've already discussed. You need to figure out what it is that you need to prove. And in doing so, you want to sort of plan out what documents you think I might need in order to believe you over the other side. Okay? What people you think could testify to what happened if there's a difference of opinion about, for example, let's say the subject matter of the claim is that you worked 12 hours on a particular day, but your employer only paid you for 8. And the reason the employer says they only paid you for 8 is because that's the time they think you left. Well, if you testify that you left after 12 hours, that might be enough for me to believe you over the employer and award the fee. Or the wages. If you have another person who is working with you at the same time and you both knocked off work at the same time, 12 hours into your shift, well, that's going to make it more likely that I will find in your favor on that issue unless the employer puts on other people who give me a reason to not to believe what you folks present. So you, in getting ready for the hearing, need to be thinking of what information you think I need to know, what documents you might have of any kind that you think would show that, which people you think might be able to testify about that, and make sure that they're with you that day at the hearing itself, okay? While I'm allowed to consider what is called hearsay, which is where you tell me what you heard someone else say outside of the hearing itself, there are limits on the uses to which that information can be put in the context of the hearing. And generally, if you tell me what someone said, I'm going to be less persuaded than if I actually hear from them themselves. And last thing that I'll say about getting ready is make sure that you show up at the hearing. Right? I mean, it seems sort of basic, but understand that if you're the employee making a claim and you don't show up for your hearing, well, what happens? Does it get dismissed? I mean, assuming that you haven't called in and said, I had a horrific thing happen and I'm not going to be able to make it today, can we reschedule? If the hearing's scheduled, you're duly noticed and don't show up, it might be dismissed at that point, okay? If you're the employer and you don't show up, well, the fact that you're not there doesn't mean I'm going to rule in the employee's favor, but the employee is the only person I'm going to hear from. So there's no basis upon which I could rule in favor of the employer unless I just completely didn't believe the employee in the first place. So those are all the remarks I had there. Again, my apologies for going over long.
Yeah.
Thank you.
Thank you, Chris.
Yep.
So thanks everyone. And what we just heard then, just as a quick recap, was what is wage theft, how it's prevalent, why we passed this policy at the city and county level, and then Eve and Paul walked us through what does the complaint process and mediation look like when you call the city or contact the county if you think you're a victim. And then Chris, of course, just walked us through what the hearing process is like. And one of the takeaways I hope that you heard is that this is a process that has been designed to be simple, to avoid a lengthy lawsuit, and to help solve issues with an employer or with employees via mediation. So we were glad to help provide you all the details into this process, but please reach out with any types of questions that you have. We're here to help.